Welcome to the law offices of Sabrina Lee. If your visa registration is terminated, this video may help you. In this video we share our team help the client restore her path to lawful permanent residence. Sabrina Lee is a certified immigration law specialist. Only 1% of attorneys in the US hold this distinction. If you're facing a similar challenge, call 213-375-8096 to schedule a consultation with us. If you found this video helpful, please like, subscribe, and share it. Our client was the beneficiary of a preference-based immigrant visa petition filed by her U.S. citizen family member. After patiently waiting for many years, her priority date finally became current while she was in the United States temporarily caring for her elderly parents. At that time, her father underwent emergency surgery to remove a tumor and required constant medical attention. With no outside help, the client became the sole caregiver, providing full-time medical and emotional support. While in the U.S., and with her immigrant visa still pending at the U.S. consulate in Guangzhou, she was advised by her prior attorney to file for adjustment of status, Form I-485, based on her approved family-based petition, and she complied. However, during the adjustment process, she received a notice of intent to deny from USCIS due to her past membership in the Chinese Communist Party. Recognizing the complexity of her case, she retained our firm to prepare a comprehensive legal response. USCIS accepted our submission and continued processing the application. Unfortunately, before a decision was issued, the client received another devastating notice, this time from the U.S. consulate in Guangzhou, informing her that her immigrant visa registration had been terminated under INA Section 203(g) for failure to maintain contact. The termination occurred because the client, who had no plans to return to China, was unaware that she needed to maintain communication with the U.S. consulate in Guangzhou to keep her immigrant visa registration active. This oversight threatened to erase years of progress and could have required the filing of a new immigrant petition, resulting in additional years of delay and uncertainty regarding priority date retention. Recognizing the severe consequences of termination, our firm took immediate action. We prepared a comprehensive humanitarian reinstatement request under INA Section 203(g), explaining that the failure to act was due to circumstances beyond the client's control. We detailed the caregiving crisis that required her presence in the U.S., her ongoing pursuit of lawful status through adjustment of status, and the procedural oversight by her prior attorney. Our submission emphasized that her inaction did not reflect neglect or disinterest but rather extraordinary humanitarian necessity and reliance on prior legal counsel. We argued that fairness and compassion warranted reinstatement, consistent with both legal discretion and congressional intent. The immigrant visa unit in Guangzhou agreed. Within a short time, the consulate reinstated her immigrant visa registration. This decision preserved her long-held priority date, restored her eligibility to continue the immigration process, and allowed her to remain on track for lawful permanent residency. For our client, this was more than a legal victory, it was the restoration of hope and security after years of uncertainty and sacrifice. This case shows that even when a visa registration has been terminated, reinstatement may still be possible when life's unforeseen hardships prevent timely action. With timely legal advocacy and well-documented humanitarian evidence, a client's immigration path can often be restored. If you or someone you know is facing a similar situation and needs the expertise of skilled professionals, the law offices of Sabrina Lee is here to help. Reach out to us today at 213-375-8096. Your American dream, our commitment.